The state of Minnesota recognizes that vital services are provided to the public by specific governmental employee groups, and therefore prohibits them from going on strike. These employees are considered essential and include firefighters, peace officers, public safety dispatchers, correctional facility guards, confidential and supervisory employees. Instead of the right to strike, these essential employees are afforded the opportunity to proceed to mediation and then interest arbitration to resolve contract disputes over terms and conditions of employment. Arbitration is a method of resolving labor disputes, a form of alternative dispute resolution, by employing a neutral third party, in this case an arbitrator, to review the facts and make a decision that is binding on both parties. There are two types of arbitration. In this presentation, we'll focus on interest arbitrator, where the arbitrator intervenes in the process to resolve an impasse in negotiations. An exclusive representative or agency may petition for binding interest arbitration involving an essential employee bargaining unit by filing a written request with the other party and the commissioner. The parties may mutually agree to use interest arbitration to resolve disputed wage issues and other terms and conditions for non-essential employees. Both the issues to be decided in the arbitration and the type of interest arbitration are subject to the mutual agreement for non-essential employee groups. The initial observation that many employers have about mandatory interest arbitration is that it gives a third person, an arbitrator, who's not responsible to the general electorate, the authority to exercise authority over wage and benefit levels. This decision could affect the amount of taxes an agency requires of its citizens and should remain solely the agency's elected officials to determine. The Minnesota Supreme Court has upheld the statutory requirement that these disputes be submitted to interest arbitration. The parties will select an interest arbitrator who's on the BMS arbitration roster. There are two methods by which the parties may select an arbitrator. The first is the parties may select an interest arbitrator that is on the list by mutual agreement. In this instance, the BMS will notify the arbitrator in writing. Usually, however, the parties do not agree on an arbitrator to hear the dispute. In this instance, the second way in which an arbitrator will be selected, the agency or union will ask the BMS for a list of arbitrators. The BMS will mail a list of 7 arbitrators to the parties within 5 working days of the request. The parties must select one name from the list by process of elimination. Each side alternatively strikes a name until one is left. Parties who are unable to agree on whether an agency or union should strike the first name must resolve the dispute by a coin flip. Most seasoned professionals require the losing party to strike the first name. When strikes are alternated, the results of the winning party having the selection between the final 2 names on the list. The BMS website includes a library of arbitration awards going back to 2006. Agencies should research the arbitrators on the list provided by the BMS to determine their preferred striking order based on an arbitrator's tendencies in prior related matters and their philosophical approach to making an award. Once the arbitrator is selected, one or both of the parties will contact the arbitrator by letter to notify the arbitrator their selection and ask the arbitrator for available dates to hear the case. The parties will then mutually select a date and time for an arbitration hearing. In instances where there are multiple or complex issues, the parties may need to seek more than one day for the hearing. The parties in arbitration must equally split the cost of interest arbitration. The arbitrator roster on the BMS also shows the fees the arbitrators charge. The procedure and presentation in an interest arbitration hearing will be controlled by the arbitrator much to the same extent as a judge presides over a court case. The arbitrator has the power to administer oaths, like swearing in a witness. The arbitrator may also question witnesses. A number of arbitrators are quite active in questioning witnesses. The arbitrator will rule on evidentiary objections and otherwise preserve order during the hearing. Typically, the parties will submit a great deal of documentary evidence in interest arbitration. Witnesses tend to be limited to providing the history of existing language or testifying about a factual situation illustrating the need for the language change that the party is requesting. Arbitrators are required to consider the statutory rights and obligations of public employers to efficiently manage and conduct their operations within the legal limitations surrounding the financing of these operations. Arbitrators are free to utilize any standards they wish in making an interest arbitration award. One of the key issues in preparing for interest arbitration and selecting an arbitrator, as noted above, is to review prior interest arbitration awards issued by the arbitrator. This will allow the agency to tailor its presentation to meet the arbitrator's preference or approach to those issues. To help clarify the standards used in interest arbitration, it will be helpful to take a closer look at a couple of issues that exist in interest arbitration. First, wage arguments. Most arbitrators agree interest arbitration is supposed to reflect what the parties would have negotiated had they been able to reach an agreement on disputed contractual terms. Let's take a look at the factors considered in interest arbitration regarding wages. Number 1. What's the internal pattern? What did other employees in the marketplace receive in wages and benefits? If all other employees received a 2% wage increase, and this group is seeking a 4% wage increase, the group asking for 4% will have to justify why they are entitled to a higher wage increase than other fellow employees. Number 2. What do external comparisons show? An arbitrator may look at what other essential employees or employees in similarly situated groups in the area received in terms of wages and benefits to make a comparison. Number 3. What's the employer's ability to pay? Is the employer able to pay the increase in wages and benefits? Public employers have an obligation to be fiscally responsible with public funds. If the public employer can establish an inability to pay an increase in wages and benefits, it might be persuasive for an arbitrator. Number 4, and finally, is there a compelling need for a change? If either party is interested in making a change to a benefit or other contract language, it's necessary to convince the arbitrator that there's a compelling reason for the change. Another argument is to show the arbitrator that an appropriate quid pro quo was offered at bargaining in exchange for the requested change. Now let's move on to contract language arguments regarding those terms and conditions of employment. In interest arbitration, new concepts are generally not favored. Negotiated changes to labor contracts are generally viewed as superior to arbitrated changes. Accordingly, arbitrators are reluctant to do two things. First, strike down matters of tradition which have helped to frame the relationship between the parties, and number 2, write innovative language designed to alter that relationship. Based on this rationale, the party proposing the change has the burden to demonstrate there's a definitive problem with the existing language and that the proposed language will effectively and efficiently resolve the problem. The burden is to show the proposal is necessary and reasonable. In the alternative, the party may meet its burden by showing it provide reasonable trades, also called quid pro quo, for the change. Where both parties are seeking to change the same language, less deference is typically given to the existing language. Now let's look at interest arbitration awards. These awards are final and binding on the parties. The arbitration decision must resolve the issues in dispute that the parties submitted to the commissioner in their final positions. The arbitrator may make an award differing from the final positions. Such an award is offered between the agency's position and the union's position. The arbitrator must issue an award within 30 days of the arbitration proceedings. An arbitrator may not request the parties waive this deadline unless the BMS commissioner grants an extension. An arbitrator not complying with this deadline will be removed from the arbitration roster for 6 months. The arbitrator will send a copy of the arbitration award to the BMS and the party representatives. The arbitrator will also report to the BMS if the parties voluntarily settle any issue before the arbitrator makes an award. The parties may settle all or some issues prior or after to the interest arbitration decision that are different from or inconsistent with the arbitration award. In the event an agency and a union enter into such an agreement, it must be placed into a written union contract or memorandum of understanding to that contract. In the event the parties resolve all issues prior to an arbitration hearing, they will be subject to any cancellation fees that might apply. These fees are typically listed in the materials from the arbitrator.